driving down the road and back.
Don't tell me what you did. I don't want to be a witness.
Do we have any idea about the jail and when they're going to be on? Or?
Yeah, they're in the waiting room right now.
Oh, okay.
They just popped up. I'd gotten a text just a few minutes ago that they were done and changing. So they must have had them in the on deck circle because they got changed pretty quick.
All right, looks like the private attorneys we have on are Johnny, Scott, Ken, and Blake.
I guess whichever one of them joins back in first is going to get preferential treatment.
Watch the race here.
Yeah, nobody in a big hurry. Hey, Bonnie.
Did I hear we were waiting for the first one to jump in?
Yes, you did hear that. Bonnie, yes. Do you have everybody that's on our list?
I like just the females, and then I'll be ready.
Okay. Well, so we can do, if you have some, we can do some men, right?
Right. Yes.
All right. All right.
To Michael Bruton then.
Yeah, let's get Michael Bruton up. I gave Mr. Bilals my word that if whoever joined up first would get their case called.
I heard it. I had somebody talking to me in the jail. I said, I've got to go. The judge is ready for me now.
Understand. Okay, so Mr. Bruton is on for 20 CR 242 and 20 CR 140, right?
Yes, Your Honor.
Okay.
And Your Honor, Mr. Simpson and I have had a conversation today. I think that he was going to speak with his client and give me a counter offer. So we need another pretrial conference date in this case, in these cases. Blake, do you have an idea about a date that's good for Alan?
I don't. Whatever you think, John. I know he did finally get a chance to speak with Mr. Bruton, and I think they are going to give you a counter. I'm not privy to what that is, but it should be. You should get that within the next day or so, I would think. So just whenever the court would like to set this, Judge, we can see.
Okay. Do you want to go ahead?
I was going to suggest 2 weeks or whatever is good for the court.
Yeah, I was going to throw out March 22nd.
He's got a mediation that day, Judge.
Okay. We could do the 15th or go one more week to the 29th.
Could we do the 29th? The 29th is perfect for our calendar for a Monday, that is.
Yeah, that works.
We'll be like Johnny and want the date that's furthest out.
Yeah, well, I wasn't going to say it.
Well, I think it's most of us private attorneys that are built that way.
Yeah, I've been there.
So March 29th, and will that be at 1:30 or 1, Judge?
Yes. Yes, it will.
So we'll say at 1, but it'll probably 1:30 before we get on.
Yeah, we usually have to wait just because of the district court docket being on Mondays too.
I understand. Thank you so much, Your Honor.
All righty. Thank you.
Thank you, Judge.
Thanks, John.
Yeah. All right.
Judge, we call Jody Tucker. I've got Scott Basil waiting on that case.
Sure. Yes, sir.
Judge, Mr. Basil and I have talked at length about this case. We've gone back and forth, but we're just too far apart on this, and we're not going to be able to come to an agreement. So I think we're at the point where we're definitely going to have to set a trial date.
Agree, Your Honor. Something could happen down the road, but at the moment it doesn't. It appears we're at an impasse.
Understand. All right.
Tucker, I will be at the jail on Wednesday to talk to you about this. Okay.
Okay. I know my family's waiting for to come make this bond for the word back. I spoke with Julie Atkins, and I had a bed date at Kentucky Christian Recovery in Morgantown. I networked with my family, got myself a bed date there, and I believe that it was told to me that the judge wasn't wanting to let me go straight from jail to there without posting the bond first. Or what was I was told they were supposed to speak with the judge about that, and I haven't heard anything back. That's what we've been kind of waiting for, was for today to find out an answer, yes or no, if I can go to that treatment center or not.
I mean, this is first I'm hearing about any treatment.
Well,
we talked about it before in court, Your Honor. I think the issue is that Mr. Tucker has to be court ordered to go to treatment.
My insurance won't cover it.
I'm sorry?
Yeah, my insurance isn't going to cover it, but I had a bed date, and I don't know if I've missed my bed date now because this was a couple of weeks ago. And the owner of the rehab, Dante Paul, the coordinator, whatever, spoke to Julie personally, and she was supposed to be getting back with me on an answer, yay or nay on that.
Yeah, I mean, I haven't. We sure talked about whether he could go to rehab. I mean, I do remember that, but I haven't heard anybody tell me that they wanted me to court order him to go. I just heard that if he got out on bond, he, was interested in going to rehab.
Yeah, and if we found out my insurance isn't going to be able to cover it, and they said something about the ankle monitor as well. But Julie said they wouldn't send me to rehab on the ankle monitor, and I mean, I can get it. I've got a bed date. If you just court order me to go, I'm saying I'm more than happy. That's what I would prefer to do.
Well, I can tell you this, and I don't want to be misleading. It was probably about a month ago, Julie did call me, and she asked about, I think she said your family had been in touch with her, and she said she didn't know anything about it. When I told her what the charge was, she said, "Oh, I don't think he's going to be able to go to rehab with that charge."
They assessed me. KCR called me and assessed me. I got an assessment done and everything. So my family knows the owner. I got an assessment. They come up here and assessed me, said they sounded like I would be okay to go through the program. And they had me a bed date. And I don't know what I'm saying. It was I think my bed date was some February 20 something, maybe something like that.
Yeah. Well, I'm not. Yeah, I'm certainly not saying that you're wrong about that. I just didn't get that information.
That's what I'm saying.
After she told me that, she asked me what you were charged with, and I told her, and she said, "Oh, I don't believe that's going to work for what they were talking about," and that was the last I heard about it.
But when I
and Your Honor, Mr. Paul reached out to me as well. I told him we're not going to be interested in that in this case. So.
Yeah, I think Julie was more thinking that it might be a component of a. The way I understood it, I think that she was thinking that it might ought to have to be a component of an agreement, because like a plea agreement or something, because of the charge and it being pre-trial. That's what I thought that was the impression I got.
No, sir, Your Honor. I was just, I can make this bond and hit the streets, you know what I'm saying? But I've been incarcerated for so long. I feel like it would have been better for me to, step down through the rehab, and I need help. You know what I'm saying? I needed help. I'm a year sober now, a year and a half sober now. But at the time, the reason I caught these charges because I was using drugs that I've never done before. And that's why I thought it'd be good for me to go to the rehab program. I was open to it. That's what my family was wanting me to do. And Julie, I think when Julie come and talk to me, she said if you would order me to go, she would, she would do everything. And like I said, I had the bed date and everything on my own, just wanting to do it myself. But my insurance ain't going to pay for it. My family don't have the money to put me through the rehab.
Well, I can check back with her and see if we've got some miscommunications here, but that's the best I can tell you right now, because that is not, I didn't get that same information when she called me.
Right.
You know, and again, maybe I'm the one that's wrong. Maybe she missed out. Maybe you're the one that's missing out on something. I don't know.
Right.
Okay.
I'll try to talk with Mr. Richardson about this before I come to see you on Wednesday.
Okay.
All right. Well, if you want me to, are you asking me to go ahead and put it down on the trial docket?
I believe that's where we are, Your Honor. Yes.
All right.
Yes, sir.
All right.
Wasn't there a day in June we had the trial set up? June 16th, maybe?
That's not going to work for me, Judge.
What's the question?
I thought we had already had a trial date scheduled.
We do. It's June the 16th, Your Honor. We're here on pretrial today to see if we could work it out. I don't see us having it worked out, but I don't know if we can have a jury trial on June the 16th either.
Probation sounds wonderful.
I don't have any idea when we're going to, I agree with you. That is when we have this set. I've got a civil trial that's also set at that time, which if that's not going to work, it'd be a good idea for me to know now, because the case that I'm talking about, the civil trial case that I'm talking about, is that Shogun, that child that got burned at Shogun. They got doctors flying in from all over the place. So, I can't cancel on them at the last minute.
Judge, I can tell you it's definitely not going to work for me. I thought it wasn't on the calendar here. So when I had set vacation time, that was the day that I set, and I thought it was clear, but that date's just not going to work for me.
We can put it in July, and just go back out, to July, because I've got multiple, we've got multiple, that whole last 2.5 weeks of July, we've got set aside for jury trials. 15th, 16th, 20th through the 23rd, and the 28th through the 30th. We've got about 100 trials set then, but, we're going to have to obviously triage those cases and give preference to people if they're in custody. So, if Mr. Tucker is still in custody at that time, then he'll be getting preferential treatment as far as the trial is concerned.
The jury trial dates that you set out, Your Honor, I can make any of those work, the 20th through the 23rd or the 28th through the 30th, I believe you said.
Judge, that 20th through 23rd, we had set Kara Basil, but that was set kind of quick. I know Mr. Tucker would have priority, and I would like to try that one over Basil first. We could set it on those days.
Oh, listen,
we've got clash.
Yeah, we've got probably 20 trials set during that 3-week period of time, so we can't do them all. But the people that are in custody, we'll just, if they don't get worked out, we'll do them. So
we had 2 days originally set for this, Your Honor. So just tell me which days we need to put aside here. Yeah.
What I've been doing, Scott, is like just that whole, the 20th through the 23rd. A trial that was a 2-day trial a year ago will be at least a 3-day trial now, because it's going to take 3 times longer to get a jury than it used to. Right. If you could get a jury in 2 hours before, it's going to take 6 hours to get one now.
Okay, so I'll just put all those days off then.
Yeah. And then we can put it on for a pretrial. We can do June. Let's see, Mike, you said you're going to be gone.
I'll be, it'll be the week, that 16th, whatever that week is, I'm not going to be here.
All right. So I guess let's put this on June 28th.
That'll work.
Your Honor?
Yes. Does that work?
Yes, Your Honor. Which time?
1. Okay.
Thank you, Your Honor.
All right. Thank you.
Judge, just to be clear, there was not a clear yes or no answer on whether I can go to that rehab or not without having to be on ankle monitor and post that 1,500, correct?
Yeah, I'm going to have to talk to Julie and see what the options are because I didn't understand the same thing that you're telling me.
Okay. All right.
Okay.
Thank you.
All right.
Thank you, Your Honor.
Yes, sir. Let's see. Mr. Garrett, what do you have?
Judge, I have, hang on just a second. I've got Jordan Johnson, I think, is on at 1.
Yeah, he is in federal custody at the Grayson County Detention Center or Grayson County Jail or whatever they call it, regional jail,
Okay.
whatever they call it. And apparently it's not any different when you're doing them remotely as when you're traveling with them. They can't allow him to participate in any hearing without getting permission from the U.S. Marshal Service, even though he's not going to be leaving the facility. So They asked us for a specific court order setting it on next Monday. And then once they got that order, which we're going to do today, then they're going to take it to the U.S. Marshals and see if they can get permission for him to participate in this Zoom hearing. So
Okay, that works.
we're going to pass it to Monday is the short version.
Okay, thank you, Judge.
All right, thank you. Do I need to write that? John? Is that it for you? Okay, must be. All right, Joshua Binge.
That's my case, Judge.
All right, sir.
Your Honor, Greg sent me an email about this case, I think it was today, and was asking about an offer. I had not sent out an offer to him yet on this case because he has an F case as well. I was going to wait till it was indicted, send out a indictment in both, a global offer. He was out of custody in that F case, but I guess recently maybe in February, he got put in custody. I don't know the exact circumstances behind that, but I've told Greg I'll make sure that he's put on the grand jury docket for this month.
I was actually arrested December 23rd for the warrant.
Okay. What, Mr. Gardner, what day did you want me to put this on?
We could have sometime, early, mid-April.
All right. Why don't we, let's put this on the 19th. Yes, sir.
I'm showing a book date of January 27th. He does have that F case for Barron as well as an M case in R.
Okay.
What's an F case in Hart?
I think
a felony case.
I think you said you had a misdemeanor case in Hart and a felony case in Barron District.
Okay.
That's correct.
Yeah.
Right. I actually was picked up in Indianapolis on December 23rd for the warrant and didn't get picked up by Glasgow PD until the 27th.
Okay. All right. We're going to put this on for the April 19th.
Judge, was Mr. Binge, was his bond revoked or?
No.
Yeah, I think he's got a bond in this case.
He's made bond in this case.
Oh, okay.
Yeah.
So it's the pending F case he's not been able to make bond on?
I would assume so. I mean, that seems like the only thing that would be logical. Unless, I mean, you can get some big old bonds in Hart County, but I think if that was the problem, he'd be in Hart County jail.
Okay.
I end up having the bonds in front of me if you'd like.
I mean, as long as I don't have him on bond, it's not my I don't care.
Understood. I was just for Mr. Barry's sake.
Yeah. I mean, yeah. What's his bond in district court?
Right now, he's looking at 2,500 in Barron and 500 in Hart.
Okay. Got that part, Greg?
I do.
Okay. Thank you. All right, Mr. Benj, we're going to put this off to April 19th. All right.
All right. Thank you.
You bet. Danielle Cowan.
Judge, I had talked to Mr. Spears last week about resolving her cases. She's got a trafficking and a possession case, and sent me a counter offer, and I haven't had a chance to, wasn't much of an explanation behind it, so I didn't have time to talk to Mr. Spears yet about it. It might be worth putting this on again in 2 weeks to see if we can try to negotiate further.
Okay. That's the 15th.
Yeah, that'll be good. And I will get in contact with Mr. Richardson about this, and we can go from there.
All right. All right. So 3:15 at 1 o'clock. All right. Thank you. Alan Cumberland.
Judge, on this one, I think we're pretty close to a deal. I have to talk to law enforcement, though. They've sent me an counter offer to resolve, but I need to talk to the police about it first. I just need a week to do that.
Okay.
That's fine, Your Honor. Also, I need a little more time to look into something else too, and to confer with Mr. Richardson to make sure that deal's good with them. So that'll be fine.
Okay. You say 1 week? Is that all you want?
Yes, sir. That's all I need.
Yeah. Hey, Mike.
Yeah.
I don't know if you know this or not, but Alan is the brother of Lisa Woodward. Obviously, she passed away, and so there's going to be some discussion probably about funeral arrangements from him being able to go to that.
Okay.
Yeah. I'm going to pass this to the 8th at 1 o'clock so that you all can discuss whatever it is that you need to talk about. Alan, hold on, let me get that up there. Let me start, of course, by saying that I'm sorry for your loss. I mean, obviously, Lisa meant a lot to a lot of people, but she wasn't everybody's sister, and she was yours. So I'm sorry for what happened. I've actually talked some to Todd, your brother-in-law, not your brother. And they're doing something on Saturday, and he wanted to know if I could arrange it for you to get there. I don't know if there are some, we got some issues at the jail with people, with coming in and out. I mean, that's why we can't really do work release and do things like that. So I know that there may be some, Josh, there could end up being some isolation or something involved if I let him go to a funeral service or something like that. So right. all I can say is that you guys might want to talk to him at the jail and find out what the side effects would end up being, and let me know whether or not that was something that he wanted to put up with, because I mean I wouldn't want to let him out for 4 hours or 6 hours or something, and then have him go to an isolation cell, and he didn't know that was going to happen.
Okay. Yeah, I was planning on going back up there and see him on Wednesday or Thursday, so I'll discuss it with him and I'll talk to the jail and find out what's going on.
Yeah, just let me know, as soon as you can so that I can make whatever arrangements I need to make to let that happen.
Okay, I'll let you know. I will.
Okay. All right, Alan, we'll try, I want you to, if we do it, I'm afraid that there'll be some, like I said, some ramifications as far as you're having to be in isolation or something, for
no, that wouldn't be an issue.
Yeah, I would want you to know it was going to happen. I wouldn't want you to be caught by surprise. Okay.
Right.
All right. Thanks. All right. Mario Fraser. Did I write down what I needed to on there?
Judge, this is my case as far as I know. When I talked to Mr. Frazier last week, he indicated that he believed that his family had retained Johnny Bell. I asked Mr. Bell, or I messaged Mr. Bell on the chat feature earlier about if he had been retained on this case, and he never responded back to me. So I was hoping he'd be on here, but so right now we really have nothing to update. Go ahead. What, Mario?
They said I just got off the phone with him before I came in here. They said they were waiting, that it took forever to get on the call. I guess some things were going on in the jail and stuff like that. But he said his secretary said that my people are up there and everything like that, and they were just waiting to connect. So maybe I can call the secretary real fast again and tell her to connect. I just got off the phone with her right before we started the session.
Okay. Well, it looks like it appears Johnny has taken the case. So
Johnny has other cases, so he's logging back on.
Say what now?
I just got off the phone with Johnny. Are you talking to me?
Well, I was asking Mr. Gardner what he said.
Oh, I'm sorry.
Yeah, I was saying that Johnny has other cases, so I'm sure that he was logging back on.
Yeah, if we want to wait and come back to it, that's fine. I know that he might have gotten off to do a district court thing, and then he's going to get back on. I don't know. But he's got other cases on here.
All right, that works.
Wait and come back.
Hey guys.
Yeah. We'll
Bruton, Cumberland, and Tucker. They'll come back.
We'll come back to you.
Okay. Thank you.
All right. He has. Yeah, this is one of them. Or two of them. Timothy Guess. All right, so what we've got, I think, up on the front end here is a new indictment that I believe we discussed the possibility of the last time we were here.
Correct.
Have we already done an arraignment on that, or yeah, we did, didn't we? This was
well, it's got a brand new indictment. He had one not too long ago. Now this is the new one. I don't think he's been arraigned on this assault case yet. I might be wrong, but I don't think we have.
He hasn't.
2142 was on for arraignment this morning, and we moved it to this afternoon because of this case.
Right. So what did I do with it? Oh, here it is. Yeah. All right, Mr. Spears. So this is what they're talking about. It is second degree assault and PFO first degree. I'm going to appoint counsel for Mr. Guess. And do you wish to have your a formal arraignment?
No, Your Honor, we waive formal arraignment, enter plea not guilty, request pretrial conference and discovery.
Okay. So we've got 21 CR 25. We've got the 19 CR 252 and the 18 CR 515. Those are set. I think we've already got pretrials set in at least 2 of those in May, but it seems like maybe we ought to try to get a pretrial before then. At least one, because his trial date's set not too long after that.
Yeah, I was going to ask that all 4 of them be set for maybe that 29th of March or the 12th of April, which should give me enough time to get discovery in this new case and talk to him about resolving all 4 cases, or see how we could approach resolving all 4 cases.
Mr. Guess, how does the 29th of March grab you?
My docket's pretty open nowadays. That sounds good.
Okay. All right. Let's say March 29th.
Yes, sir.
Okay.
Yes, sir.
All right. Thanks.
Thank you. Mr. Spears, we're going to have that paperwork up here today?
It's already at the jail. They should be giving it to you hopefully sometime today.
You're a fine gentleman, scholar. Thank you. Am I good?
Yeah.
Yes, sir.
Thank you.
Jay Hicks.
Your Honor, in this case, Greg has given me a counter offer. I think it was either Friday or this morning. I can't remember which one, but I'm not ready to commit to anything at this point. If we could have another pretrial conference, I'll speak to Greg about this case.
That's correct, Judge.
How when would you like that to be?
Your Honor, I'll leave that up to the court as far as your docket. I mean, I can turn it around as early as next week, but if you need more time, as far as docket wise, I'm fine with that as well.
Yeah, you know, I mean, I've kind of lost track of how many we've got on each day. As many, you know, just as much with the weather, and we've had to pass a lot of things and all that. So, I mean, 2 weeks is fine, a week is fine. I don't care. What, Greg?
March 8th is pretty full, looks like, if you want to go to the 15th, Judge.
Yeah, I'm sure it's probably looking pretty rough. Okay, that's fine then. We can call it 15th.
Okay.
All right, March 15th at 1 o'clock.
Thank you.
Terry Huddleston.
Judge, my notes from last time reflect a discussion about, I guess, the Casey's Law petition, and that was being challenged. And I don't know about competency, whether there needs to be, you know, that's being addressed, or it needs to be.
Yeah, I don't know anything about the status of that stuff in district court.
I think Terry knows. You know, don't you, Terry, what date y'all got a hearing on that?
It's tomorrow, yeah.
Tomorrow? Okay.
Yeah, tomorrow. And I got the other discovery that you said you didn't see.
Mm-hmm.
Okay. Well, are you wanting to
look at the numbers?
Do what?
Look at the numbers, let's say.
Yeah.
My lawyer.
we can, I'd say that what's going to happen is you're going to have your hearing downstairs or in district court. And I don't know that you're going to have is the hearing tomorrow about whether the law is constitutional, or is it just about whether he's going to order you to go to a treatment facility?
He's saying it's not, he's saying it's constitutional, but I don't know whether the lawyer is going to still argue further or not. That's the district court judge now.
I understand.
It's just back on. All I know is back on the docket with Jeff Joe stuff. The guard.
Well, I guess what I'm trying to figure out is we need to give you another date, and I don't really know how far, I don't really know how far out I need to do that.
Let's say 2 weeks.
I want to see, what's going to happen in the district court thing right now too, because that's influences what we're doing.
Right.
Let me find, looks like looks like there hasn't been an order done yet on that constitutional challenge, because it was set for 2/19, and then the 2/19 it just got passed to tomorrow. So I don't know if there was a weather problem or what happened.
Mrs. Hill, she knows more about it than I do. The attorney does.
Sure. Well, do you want to pass it 2 weeks and, kind of see where we are? And then Mr. Gardner, your point is well taken, which is, are we going to be, is any sort of competency thing going to be implicated? And I think we need to wait and see what they do in district court first. So, I'm looking at either 2 weeks or 3 weeks, just whatever works best.
So after tomorrow's decision, and we'll talk to Julie and said something about maybe a place in Tompkinsville. So we live in a house in Tompkinsville or somewhere. Maybe get me out on bond until we can maybe get it resolved. Okay,
yeah, so. I listen. I'll listen to anything. Okay. Why don't we put it on for March the 22nd, just so that there's enough time for all this to get done. What I'll do is I'll check. I'm going to ask Crystal if you'll do this, but we'll check with district court and ask him to send us a copy of whatever order he enters in that case.
All right, Judge.
Okay.
Yeah.
All right.
Thank you.
Bobby Johnson.
I filed his plea agreements, Judge.
I believe I have them.
Judge, just so you know, part of the deal is I've agreed, and we initially made this agreement, or I had made the offer when his current case, he hasn't been arraigned on yet, the 21 CR 40, when that was an F case, I had offered to dismiss that if he stipulated to probable cause, if he pled to the other two for 8 years. So that is part of the deal, is on that 21 CR 40, I would dismiss that, but he needs to stipulate the probable cause.
Oh, I see. So that's probably not necessarily written into the.
I didn't see it in there, Judge.
But I mean, that's the reason. That's the reason you're bringing it up, is just so that I can discuss it with him, right?
Right. Yes, sir.
Yeah. Okay. So what'll happen if this goes through is that he's got the 2 cases he'll be entering a guilty plea to, right?
Yes, sir.
All right. So go ahead and raise your hand, Bobby. Please. Do you swear or affirm that you'll tell me the truth, so help you God?
Yes, sir.
All right. I'm going to get this up here where we can see it. Okay. You've got 3 cases on the docket here, Mr. Johnson. One of them is 20 CR 130. You got 20 CR 339, and you've got 21 CR 40.
I don't have that one.
No, but I'm saying it's on the docket.
All right, yes.
Yeah. And what Mr. Richardson was pointing out is that the 20 CR 40, that part of what his offer initially was to you was that if you pled guilty in the 2 20 CR cases, that he would dismiss the case that became 21 CR 40, in addition to in addition to the other elements of the plea offer that he's made to you. Right?
Right.
Right. But part of the, I guess a condition of that dismissal would be that you would acknowledge on the record that there was probable cause for the charge or the indictment in 21 CR 40. Do you understand that?
Yeah.
Which is, for the record, possession of a controlled substance, 1st degree, 3rd offense, or subsequent possession, 3rd degree, and possession of marijuana. You understand that?
Yes, I do.
So nobody's asking you to plead guilty to it, but you would be acknowledging that there was probable cause for the charge, which, I mean, that you got indicted, so that's what that means anyway, is that there's probable cause, right?
Right.
All right. So I have put you under oath, and I want you to take a look at this document right here. It's called Motion to Enter a Guilty Plea. Have you seen this document before?
Got it right here in front of me.
All right, good deal. And there's a signature on it. Is that yours?
Right on the back.
All right. Mr. Berry, did Mr. Berry go over that with you?
Somewhat, he did.
Huh?
Yes, he did.
Fair enough. All right. So before you signed it, did you make sure that you understood what you were signing?
Yes.
All right. Do you understand that you have the right not to incriminate yourself, and if you plead guilty, you waive that right?
Right.
You have the right to a trial by jury where the Commonwealth has to prove guilt beyond a reasonable doubt. You can confront and cross-examine witnesses. You can put evidence on in your own defense, and you can appeal. Do you understand that you waive each of those rights if you plead guilty?
Yes, sir.
All right. Mr. Johnson, are you under the influence of anything today?
No, sir.
Is your judgment impaired for any reason today?
Nope.
All right. You also, in each case, have an offer from the Commonwealth, which looks a little bit like this. Does that look familiar? Yeah, you've got one with you. And there's a back page to each one.
Got it.
All right. Is that your signature?
Yep.
Okay. Did you make sure that you understood that document before you signed it?
Yes, sir.
Okay. All right, Mr. Johnson. As I go through that, let's make sure that we understand what it says. The recommendations of the Commonwealth are as follows. Count 1, fleeing or evading, 1st degree. That's a Class D felony. On a plea of guilty, the Commonwealth would recommend a 3-year sentence. Count 2, possession, 1st degree, 3rd or subsequent offense. A D felony. On a plea of guilty, the Commonwealth would recommend a sentence of 3 years concurrent. Count 3, criminal mischief, 1st degree, a D felony. On a plea of guilty, the Commonwealth recommends a sentence of 3 years concurrent. Count 4, fleeing or evading, 1st degree. On a plea of guilty, 3 years concurrent. Count 5, DUI, 4th offense, a Class D felony. Commonwealth agrees to recommend 3 years plus the DUI service fee, DUI counseling license suspension. Count 6, driving on a DUI suspended license, second offense, aggravator. The aggravator in that case by statute is a simultaneous DUI, which is count 5. So Commonwealth recommends a 3-year sentence on that Class D felony. Count 7, resisting arrest, that's a misdemeanor, 12 months. Count 8, criminal mischief, 2nd degree, an A misdemeanor, 12 months. Count 9, criminal mischief, 3rd degree, a B misdemeanor, 90 days. Count 10, PFO, 1st degree, a sentence enhancement. The Commonwealth agrees to a dismissal on a plea of guilty to counts 1 through 9. The total recommended sentence in this case would be 3 years plus those DUI penalties that we alluded to earlier, and the possibility of restitution to be determined by some definite date in the future, and we'll talk about that in a minute. The Commonwealth opposes probation. The sentence in this case and the sentence in the next case that we may be talking about in just a second is going to be by recommendation of the Commonwealth pursuant to applicable law consecutive. And it would be consecutive with any other sentence that you have prior to these. Is this what you understood the offer to be in 20 CR 339?
Yeah.
All right. Other than what you and I just talked about, have you been promised anything or threatened with anything to try to get you to plead guilty? Other, of course, than what we talked about a minute ago, which is Mr. Richardson agreed also to dismiss 21 CR 040.
Right.
All right. So no other promises and no threats, right?
No.
No?
No.
Okay.
I told him that I was hoping to be able to get out until final sentencing. Is that going to be maybe where I can go? Okay.
Hold on. But
okay.
but Mr. Richardson didn't promise you that would happen, did he?
It ain't on the plea.
Well, you're acknowledging that he did not, that isn't part of the deal, right? You're just going to ask and I'm going to decide that.
Well, I guess, yes.
Right?
I guess, yeah.
Yeah.
He's on to say he asked me about it, Judge, but.
Right, sure. And I'm going to ask you in a minute because this is just something that has to be clear on the record that he understands that that's not part of the only thing the Commonwealth has said as far as other than recommending these sentences is that they oppose probation. So they haven't said anything about agreeing to any kind of bond pending sentencing or anything like that.
Okay.
Is that fair?
Okay. Yeah.
Yeah. All right. All right. So, Bobby, are you acknowledging that on August the 18th, 2020 in Barron County, you committed the offense of fleeing or evading in the 1st degree when you having the intent to elude or flee, you knowingly or wantonly disobeyed a direction to stop your motor vehicle given by a peace officer, and by doing so created or caused a substantial risk of serious physical injury or death to any person or serious property damage?
Yes.
Are you also acknowledging at that same time and place you were in possession of a Schedule II controlled substance, which was methamphetamine, having at least 2 prior convictions for possession of a controlled substance?
Yes.
All right. Are you admitting that you committed the offense of criminal mischief in the 1st degree when, having no right to do so, you intentionally or wantonly defaced, destroyed, or damaged a 1999 Volkswagen Jetta belonging to another person, causing damage of $1,000 or more?
Yes.
All right. Are you admitting that at that same time and place you committed the offense of fleeing or evading 1st degree when, as a pedestrian having the intent to elude or flee, you knowingly or wantonly disobeyed a direction to stop? I'm sorry. Knowingly or wantonly disobeyed an order to stop given by a police officer, and by doing so, you caused or created a substantial risk of serious physical injury or death to any person or serious property damage?
Yeah.
Yes. Are you admitting that at that same time and place you were operating or in control of a motor vehicle under the influence of a substance or combination of substances that impairs your ability to drive as measured by a scientifically reliable test taken according to statute, and you have at least 3 prior DUI convictions in the last 10 years?
Yes.
All right. Are you acknowledging that you committed the offense of resisting arrest when you intentionally prevented or attempted to prevent a peace officer from arresting you by using or threatening to use force?
Yes.
All right. Are you acknowledging that you committed criminal mischief second degree when, having no right or reasonable grounds to believe you had a right to do so, you intentionally or wantonly damaged property belonging to South Central Property Management, lost $500 or more?
Yes.
All right. Criminal mischief third degree, you intentionally damaged or destroyed property belonging to another person, causing damage under $500.
Yes.
All right. Let me get my breath.
I really went and done it this time, didn't I, Judge?
Well, no half measures, that's for sure.
Try not to.
Yeah. Now, looking at the next case, 20 CR 0130, fleeing or evading police in the first degree, Class D felony. Commonwealth recommends a sentence of 5 years. Count 2, possession first degree, third or subsequent offense, a Class D felony. The Commonwealth recommends a 3-year sentence concurrent. Count 3, drug paraphernalia. The Commonwealth recommends a 12-month sentence concurrent. Count 4, marijuana possession, a 45-day sentence concurrent. 6, speeding. Commonwealth agrees to dismiss. 7, PFO first degree. Commonwealth agrees to dismiss. Total recommended sentence is 5 years. 5 years in this case to run consecutively with the 3 years in the previous case and consecutive within the other prior case. Commonwealth opposes probation. Commonwealth agrees to dismiss 21 CR 40 upon stipulation of probable cause, which we've already discussed. Other than those promises from the Commonwealth, have you been promised anything or threatened with anything to try to get you to plead guilty?
Yes, sir.
Are you pleading guilty voluntarily today, Mr. Johnson?
Yes, sir.
Are you acknowledging that on or about October 21st, 2019 in Barron County, you committed the offense of fleeing or evading first degree when operating a motor vehicle and having the intent to elude or flee, you knowingly or wantonly disobeyed a direction to stop your motor vehicle given by a recognized peace officer, and by so doing caused or created a substantial risk of serious physical injury or death to any person or damage to property?
Yes, sir.
Are you acknowledging that at that same time and place you were in possession of a Schedule II controlled substance knowingly and unlawfully? That substance was methamphetamine, and you have at least 2 prior convictions for possession of a controlled substance?
Yes.
All right. Are you acknowledging that you were using or possessing with the intent to use drug paraphernalia?
Yes.
And that you possess marijuana?
Yes.
All right. I shall accept your plea of guilty in both of those 2 cases. Mr. Richardson, are you planning on, I don't think you have to file a motion, but are you going to submit just an order of dismissal or?
I can, Judge.
On that
draft order. I didn't know if it could be just done on the record, or the only thing I wanted to have it noted was that it was being dismissed pursuant to a guilty plea.
Yeah.
But I could do up an order or something.
Well, and that part is on the record, but if we're going to dismiss something, I like, you know, since I do everything by e-filing, I can't get these calendar orders uploaded. So if you can just submit a order, it doesn't have to be agreed, or you don't have to file a motion with it. Just put it in my e-filing and I'll sign it.
Yes, sir.
Thank you. So Mr. Johnson, I'm going to accept your plea of guilty in both of those cases, like we said, and reading between the lines here, Mr. Berry, I'm thinking you're going to ask me to get a PSI and set this out for a sentencing on another day, correct?
I am, Judge.
All right.
Bobby wanted to know if the court would consider reinstating his bond.
I'll still be supervised by probation and pro until the final sentencing.
Yeah. Brandon, Officer Bragg, I'm sorry. Is this something that you think we could get a sentencing done by March 29th? I mean, a PSI done by March 29th? I mean, that's 28 days. That ought to work, shouldn't it?
Yeah, because he just had one in June, so it'll just be a supplemental, so it shouldn't be a problem.
Yeah, I mean, and he's on active
Yeah.
probation or parole, or what'd you say, probation?
It's probation.
Yeah. All right. All right, Mr. Richardson, what's your what are you going to say about it?
I was just going to say, Judge, I didn't make any promises about me. I'm glad he's accepting responsibility, but I didn't make any promises about agreeing to him getting out. I mean, these are serious charges. He has a long history dating back to, I think his earliest felony case was back in 2000. Long list of drug charges. He's a lot of DUIs in these cases. He's got fleeing and evading. He put people's lives in danger. And he was fleeing and evading within residential neighborhoods, was damaging property. I mean, I think, you know, my job's obviously not to represent him, it's to represent the Commonwealth. I think the people would feel a lot more safer if Mr. Johnson was locked in jail. So I'm not going to agree to any of that. And I'd ask that you keep him in jail. I understand. But Mr. Johnson, let's talk about a couple things first. Number one, can you tell me, and the answer might be nothing, so I'm not trying to put words in your mouth. I mean, is there some specific thing that you want to achieve if you're out for 3 or 4 weeks or whatever?
I'm going to be working, and I'm going to call my lung specialist and see my lung specialist in the process. I was supposed to send him while I was out, and I've got before my doctor's appointment, I got in trouble and missed my doctor's appointment. So yeah. Okay.
Let me ask you another question. Do you understand that the Commonwealth, a condition of both of these recommended sentences in these two cases is that if you have a period of time between your entry of your plea and your sentencing and you are on bond, that you follow all of your conditions of bond. And if you were to not follow your conditions of bond, or if you were to not show up for your final sentencing or otherwise fail to comply with anything that I ordered you to do, they would not have to make any of these recommendations that they've agreed to make. It's a two-way street, right?
Yes, sir. Yes, sir.
And you know, in one of these cases, well, in both of them,
well, you know, I've done a lot of prison time. I mean, I've always owned up to my what I've done. I mean, you know that. I mean,
listen, I'm putting this stuff on the record. Okay. And the reason that I'm doing that is because if I agreed to do this, you know, I have done this before, and it has come back to bite the defendant squarely on the hind end because they've had I can think of one case in particular that the guy was basically going to get a 360-day sentence, and he went out and failed to comply, and he got a 15-year sentence.
I understand.
There's a big difference in 360 days and 15 years.
Definitely is.
And it was because I tried to talk him out of asking for this, and he persisted, and so I thought I'd give him a chance, and I did, and he blew it.
I understand.
So that is the whole point that I'm making with you, is that you could have a substantially more, you know, a substantially greater sentence if the Commonwealth didn't make these recommendations, which they won't do if I did let you out and you go out and screw up.
I understand.
All right. Mr. Berry, as far as that request goes, do you feel like Bobby understands what it is that he's asking for and what the downfall might be?
Oh, yes, I do, Judge.
All right. I'm going to make, let me do this. Bobby, I'm obviously, you know, I indicated to you when we talked about it before you ever even entered your plea that I would think about it. And I'm not, you know, playing a bait and switch on you. I don't know exactly what the best way is to do it. So I'm not going to tell you right now what we'll do, but I'm going to put your sentence on March 29th at 10 a.m. And, you know, I'm going to try to figure out some way to make this work. I mean, I do think you have we did talk about this. I know you got some medical issues, And I think you probably ought to go to see your doctor. And if you have meds to get, I don't know if you take a inhaler or whatever, your nebulizer or whatever you have, atomizer or whatever it is. All right. So, I think it's fair to give you the opportunity to get some of that done. I'm just not sure what the best form is for it to take, but I'll come up with something.
All right.
I just can't tell you right now.
All right. Thank you.
But I do want to make sure it's clear that this requires you to live, you know what I'm saying, I don't want to use an inappropriate phrase. So I just want you to understand that you got to follow all the rules if you do get out, or it's going to come back to haunt you. And, I won't be able to do anything about it. Cause if you get, you know what I mean? Sometimes you get what you ask for. Okay.
Right.
All right. All right.
Judge.
Yes.
I'm having some transportation issues with my child. Can I think Mike's got some cases. If I could check out of here and appear by phone, do you have an objection to that?
No.
Okay. Thank you so much.
Judge, if we can call, the next one I have for me is Stanley Merrill.
Okay.
He had an arraignment.
Yeah, Mr. Merrill.
He has a new arraignment, Judge.
Okay.
Yeah.
Josh, I don't think we talked too much about his new case, have we?
No. We need to sit down and talk about it, or sometime this week or next.
All right, so that case is 21 CR 43. That is a possession of handgun by a convicted felon. That's a Class C, and PFO first degree. I'm going to appoint counsel for Mr. Merrill. Mr. Spears, I'm going to assume you'll catch this one, right?
That'll be correct.
All right. So do you want formal explanation of rights or charges?
No, Your Honor, we waive formal arraignment and plead not guilty, request pretrial conference and discovery.
Okay. Can you, if I gave y'all to March 22, would that work for you to have a sit down?
That should work.
That's fine, Judge.
And then give you enough time to get with Mr. Merrill if there's anything to get with him about?
Yeah, that'll be fine.
On both these cases, 3/22 at the 1 o'clock docket. Okay. Plea of not guilty, counsel appointed. All right. Thank you.
Thank you.
Mr. Bell.
Judge, quick call.
Well, I was just going to say I think I called a couple of his while he was on his walkabout. So if he wants me to call those.
I was in district court, Judge. They made a demand to be in district court. So if you want to beat up on anybody, please go downstairs and beat up on the district court Judge Gabe Pendleton.
I'm not planning on beating up on anybody. But while you were gone, we called, you might have noticed we're kind of going in a general alphabetical order. So I called Mr. Frazier, who I was told that his family or something had recently employed you. And then
that's correct, Judge.
Yeah. So let's get Mr. Frazier on. Is this my Mr. Richardson? Are you doing this?
No, I don't know if it's John or Reese's, but
I guess it's Mr. John Gardner. Is he gone?
I believe so, Judge. I mean, I can stand in. I don't know anything about the case, but.
Well, did I understand somebody to say that there is another case in the grand jury pipeline, or was that wrong?
I'm not sure, Judge. I mean, I
I
can
have
text John and see.
no idea about that, Judge.
So you're just hired on this one case?
Well, I mean, that's the only case that I know of right now.
Okay. I thought he said something about, and there was a lot of background noise, so I was kind of missing out, I guess. I thought he said something about that they had hired you to represent him in his F case in district court, and they were trying to get you to hire him in this case, but I must have misunderstood that.
The only thing I know is there was a case in Bowling Green.
Okay.
That's about the only thing we've got left.
Are you doing that?
No, he doesn't need anybody to have it. I think it's kind of taking care of itself.
Oh, okay.
Yes. Warren County, last time we talked, you thought I had a hold, but my mom was just sick. COVID was going on, and she couldn't come all the way down here to sign me out. So they changed the name to my mother and my kid, and she signed me out. So I had a surety, but it looked like a hold, I guess, to the Commonwealth. And now she had changed it. I think it was the 2 days after I had court, but it got changed the day after I had court, but we didn't get it signed. I can't remember the date by heart. I think it was the 28th or the 29th. I have it back there on my room or whatever. Like, I just forgot to bring it. But I have a signed surety in Warren County. You said that was the only thing that was waiting for it, because I had a surety here too, and it got changed, I guess. And you had told me, I guess it was because of the Warren County hold. But they said they weren't going to hold me, and that I needed to go talk to my public defender down there for my case down there, because I'm trying to get that one situated for. I mean, I know I can't really put this one on pause, but that one's probably like, I mean, it's really important. I've been fighting that one for 3 years, so I know he wanted me to come down there and make a game plan on him on the next time we went to court. I haven't really been able to talk to him because he said he can't come up here, all the way up here to Glasgow to talk to me.
The main issue that we've got, Judge, is hoping to address his bond situation due to the fact that Barron County is the only thing holding him at this time.
What's his bond in his robbery case?
They give him a surety in Bowling Green. He's out on that.
Well, his bond in this case is $7,500, which was based on him having a high FTA number and a moderate, but on the high end of moderate reoffense number, risk to reoffend number. In addition to there being 3 pending Warren County felonies when this case got picked up.
And they have, as I said, Judge, this is the only hold on him right now. And I believe Mr. Frazier would be willing to put on an ankle monitor or whatever we need to do to help the Commonwealth and the court to feel like that they were adequately supervising Mr. Frazier. I would like for him to be able to at least fight these, being he's been released down there on those cases. And from my understanding, this here is more of a domestic than anything else. And, I don't know if they've reached the level of assault second or not, but I've not had an opportunity to look at that very much.
Yeah. Yes, Your Honor. I'll abide by stipulations I need to on the bond. I know I got a risk, but it was in Warren County where I missed court when my brother had got shot. And I let the judge know that, and he had let me back out on bond the last time, and that was a year ago. I haven't gotten in trouble since 2019. So I know it says risk on there, but I mean, I've talked to the judge down in Bowling Green when I first called the charge or whatever like that, and they willing even to take most of my charges to misdemeanors, and the only one that was charging me with was the missing court. And I explained to him why I missed court and stuff like that, because he had no idea what happened. My brother had got life lifted into Vanderbilt and made the news last year. So that's the only reason I've ever missed court. And I did make a mistake back in 2018 when I was, fresh as an adult, and I did flee and evade back then, and I took my charge. And ever since then, I haven't missed court. I'll make every court appearance. And if I have to be on an ankle monitor, it doesn't, it doesn't matter to me.
Okay. Yeah.
I mean, I don't know if we're able to bond here now or not. I mean, it's not my case, but looking at his charges in Warren County, I mean, he's got like pending bail jumping charge, robbery. Now he's got an assault here. I mean, I think you had said it was $7,500 cash is what you had said. I mean, I think is more than reasonable looking at what he's facing right now.
Yes, sir. And they had agreed to take my Warren County's misdemeanors. I haven't got a chance to talk to my attorney yet. So yeah, I'm not charged. I mean, I'm charged with robbery, but the paperwork is he's taken off robbery and everything.
Well, you know, all that set aside, you know, I mean, constitutionally, he's presumed innocent until proven guilty on all these charges. And, you know, I hope the court will take under consideration implementing some protections or regulations or restrictions on Mr. Frazier. He does have a place to live. He can wear an ankle monitor, and he can abide by home incarceration or whatever the court would want him to be on. How long have you been in jail now, Mario?
About 4 months. Since November 9th or 10th, I'm pretty sure.
Well, what's your address?
I can't remember it by heart, but it's on my document paperwork. It's on all my paperwork. I live in Glasgow, right next to Red Cross, but I just moved. You know what I mean?
It's 103 Noah Drive, Your Honor.
Yes, there you go. Thank you.
Okay, so that would be his address if he were to get out.
Yes, Your Honor. 103 North Court, Apartment C.
I understand. Well, there, you know, it is a different situation than it was the last time I saw him because he had those holds in Warren County, and those obviously aren't still an issue now because he's been released from over there and he's over here. So I don't really know what happened in those cases. I will take a look. It's been a while since I've looked at this because I think when I saw Mr. Frazier last, it was probably late November, early December, something like that. Yeah, it was December December the 20th or something like that. So I'm going to have to refresh my memory, but here's what I'm going to do, Mr. Bell. I'm going to put his pretrial on for, you're just now getting in it. So I know you don't really know much about not, you know.
That's true. I do not.
I'm going to put his pretrial on for April the 26th. I'm going to take this bond request under advisement, and we'll get some kind of order out on that this week.
Your Honor.
All right, Jared.
Can I say one more last thing, please?
Okay.
I have a child due April 20th, and I ask you, could you please take it under advisement, you know what I mean, any bond stipulations I have to agree with to at least be able to see my child be born. I understand I've messed up, you know what I mean, and I've messed up in the past, but it's my first time seeing me in orange, and this will be your last time seeing me in orange.
I already told you I'm going to.
Okay.
Okay. All right. So when, you know, assuming that you make whatever the bond is, you need to stay in contact with Mr. Bell, you know, religiously. Okay.
Yes, sir, Your Honor.
All right.
Thank you. Everybody have a nice day.
Amen. The only other case I've got is Kyle Gardner, Your Honor, if you want to take it up, or I can.
We can. I think John is off of here, so I don't know if there's anything that we need him for, or if Mike can stand in on that.
I mean, I don't care to stand in.
Oh, okay. Yeah, you're back.
All right, knows more about it than I do. Yeah.
Well, I think what we're here for, Judge, was over that mediation, which we discussed the other day. I still need to go talk to John about that. We've talked about it quite a bit, as we said the other day. I think that's basically what we were on for. I think we've got trial dates. If not, we do need to get those.
So you just need to discuss this mediation with John. Is that correct, Johnny?
Yeah, it was just a situation where that he didn't want to go into it if we didn't have some opportunity of resolving it, and due to circumstances and situations right now, not being able to go talk to Kyle and things, which I think will remedy here pretty soon. We just haven't decided to do it as of yet.
Okay. How many weeks do you think you need?
To be quite honest with you, I'm waiting on I would like to be able to go sometime after March 26th. It may be too long, but
he must have had the Moderna.
I mean, I think if there's already trial dates set and we're not moving the trial date,
wait.
I don't know that that would be a problem necessarily.
I don't think that I have a trial date on this, Mr. Bell.
I'm not sure that we do either, Judge.
I thought that you had said that we did.
He did say that, but I mean, far be it for me to call a fella wrong, but I don't think he was right.
Well, we have set
anything
several
between wrong and right. That's where he was.
We've set some trials in this case. It's just under the environment, they've been moved around and pushed around to the point that sometimes we get a little bit lost.
I think we've had a date before. It's just hadn't materialized due to things beyond our control.
I guess what I would ask, since this is John's case, and John, if you have cases on the docket next Monday or the following Monday, that we pass it.
That's fine. We got 2 weeks, Judge.
Even if you don't get a chance to go down and talk about the mediation and all that, I think if I'm going to set a trial date, it'd be better if John was on here so that I knew that it was.
I agree.
I was personally telling him what the date was.
That's fine.
So,
Your Honor.
Yes.
Are we going to be moving the Barron and Metcalf together?
Yes. I don't have his Metcalf file over here, do I?
I'm just going by what my file had Barron and Metcalf put together, the Metcalf 20 CR 62.
Yeah, you're not wrong. I just don't think, I was just asking if I had his file up here. We've been talking about all those cases at the same time,
Understood.
Yeah.
For purposes,
I just wanted to make sure I had it passed along right.
Yeah, you're right. Mr. Bell, why don't I put it on, I mean, if it's just to I can give you a date real soon so that John will be on here, and then we can pick a trial, and then you all can still talk about your mediation, all that. Or I can put it out 4 or 5 weeks to give you the chance to do all that and then do it all on one day.
No, I just get John on there, and we'll go from there.
All right.
When we come back next Monday or the next, I don't care, Judge. It's fine with me.
Next Monday's fine.
Okay.
Put it on the 8th at 1.
All right, that'll work. Next Monday at 1. All right.
All right, Mr. Bell, is that it?
Yes, sir. Thank you, Judge. Y'all have a good day.
Be good.
Judge, can we call Stanley Merrill?
We already did him, didn't we?
Oh, I'm sorry.
Yeah.
Sorry, Quinn Ritter. I meant.
Quinn Ritter.
Judge, Mr. Ritter, it was Mr. Berry's case, but Ms. Myers, I was told, has taken over. So she just now looked at discovery, I think, this past week, and she had requested some more time, which I don't, I kind of expected anyway. So I just need to set it out a little bit for another pretrial conference. And I've already sent discovery and my offer, so they've got all that.
Your Honor, I have received the Commonwealth's discovery. I was going to ask for a little bit of time, though, because I have some additional work I need to do on the case. So I was going to ask that we set it out for either May 24th or May 31st, if the court was okay with that.
Yeah, one of those days will be Memorial Day, but I don't know which one.
I don't either.
Which one is going to be Memorial Day? You want to look that up?
I think Memorial Day is the 31st. So if we set it for the 24th.
So Memorial Day, is it always the last Monday? Oh, so it's not like one of them fourth Mondays or whatever. It's the last Monday. You'd think I'd know. I'm 52 years old. All right. So the 24th?
Yes, Your Honor.
All right. Okay.
Judge, can we call Fabian Sebastian?
Yes. Yes, sir.
Judge, I've sent my discovery and my offer, and Miss Myers, I think she sent an email today or Friday. I think we're really far apart on as far as resolving the case, but it's the first time we haven't really sat down and I guess thoroughly talked about it. So there's nothing that we can really do today. We just have to, I guess, set it for another pretrial, and I'll talk to her and see if we can try to resolve it.
All right. Ms. Myers, what do you have in mind on that one?
I think we could probably set it out to April 12th for another pretrial conference, and perhaps that'll give us some additional time to try to resolve the case. Your Honor, I was going to ask you to review Mr. Sebastian's bond today. I was showing that he is low risk for both NCA as well as FTA. Additionally, he's never had any prior felony convictions. He's actually from Kentucky, so I do expect that he would be staying in Kentucky. So I was going to request that the court take another look at his present bond status.
Okay. Mr. Richardson, you want to say anything?
Judge, you've held, and I know that bonds, you do constantly review, but you've already held that he is a danger to the public, and I think that was the right decision. This is a Class B felony, and Mr. Sebastian was found with the firearms and drugs, and this isn't just simply an amounts case. If we go to trial on this, there will be testimony that Mr. Sebastian is dealing. So, I mean, we do think he's a significant risk to the community, and I think his bond should remain where it's at.
Yeah, I mean, I think you can always ask me to look at it, and I don't mind looking at it again. I don't know that I'll modify anything because I think it was I think there was a fairly significant modification the last time, but he clearly hadn't made it, so that makes it worthwhile. It's a legitimate request for me to look at it again, and I will. Okay.
Does have family members in the area too, Your Honor, that I believe have been indicating that they would like to try to help him with bond. I don't have a specific amount that they can put up. I will state, not to try to get into the facts of this case in too much detail, Your Honor, but I don't believe he was charged with a stolen firearm or anyone's trying to claim that the gun that was found in the motorcycle was hot by any means. So there is that, and I have received the discovery. I'm not trying to try the case before you in the bond motion, but he has no prior felony history, Your Honor.
I understand, and I don't disagree. I don't think there's any stolen firearm allegation. There's just a firearm allegation. So
there's an enhancement.
Yeah, an enhancement. Yeah, but I'll take another look at it. Okay, when I get a minute.
Thank you, Your Honor.
All right, thank you.
Judge also had Jesse Turner.
Judge, this is my case.
Yes, sir.
We've got Mr. Turner and I a case down in Monroe County also. It's got substantially, I think, more charges to it than this case. And I had proposed that we set this case off until we resolve the Monroe County case, either by trial or plea bargain, Your Honor.
And Judge, on my end, I've talked to Jesse Stockton about his case over there, and I think they almost had an agreement, but it fell through. So I would expect if there's not a trial date set, that there will be one set. As Mr. Berry said, they've got significantly more charges, and it all involves the same victims in our case in a different type of matter. So on our end, I don't wish to re-traumatize the victims when there's a much more serious case in Monroe County. So I would expect that if they set a trial date, I think their next pretrial is March the 18th. I would expect that their trial would be set pretty not too far out. So I wouldn't be opposed to moving this out. We're not just moving it to do so. I mean, I've got my own concerns as well.
Well, Greg, are you expecting when you go back in mid-March that they'll pick a trial date at that time, or do you know?
I would say I've not had Judge Williams's court since the new order came out. So I'm not real sure how quick he's going to try to jump on things and get jury trials moving again. So I guess my bottom line answer is I just don't know right now.
Well, why don't I, a long time ago when they used to do things over there, if they didn't get anything done on the one, they just had pretrials once a month. And, they would just kind of automatically put it from 1 month to the next month. Do they still do that? I mean, if you don't pick a trial in March, will you have another pretrial in April? And
I doubt it unless there's some good reason that we're saying we need some more time to work on the case before it's set for trial.
It used to just kind of be automatic that your pretrial, you would just go every month until there was a trial date but of course it's been 20 years, 15 years since I was over there.
Yeah, there's still just one motion day a month. And it's not necessarily automatically just put off another month. So I think Mr. Stockton may be pushing to go ahead and get this set for trial as quick as he can.
What I was going to do was maybe put it on a pretrial date in May, and just not so we're not rushing back in here if something hadn't got done, and then that there's probably a pretty good chance you'll know when your trial is by then.
That's true.
What will let's put it on May 24th, because that'll be after the pretrial day in May in Monroe County.
Okay, Judge.
All right. Thank you.
Judge, I believe that was all of mine. I don't know if Risa can hear me, if she can handle the rest or not.
I can, I believe. I'm almost back at the office, but I can do it.
I could do one or two more just so you don't, so you can pay attention to driving or whatever. I don't know which ones.
I don't think that there's much in my cases that needs to be discussed. I'm good.
Okay.
Thank you, though.
I guess, Judge, if you just want to call whatever down the list.
Timothy Allen Miller.
That's John's case, Judge. It's my understanding that an offer's been sent and that John hasn't heard anything back from that.
And Your Honor, Greg Price, I got that just transferred me 2 weeks ago, Your Honor.
Yes, sir.
Okay.
I just received discovery and I got that offer today. So Mr. Miller, I'm going to get that out to you in the next week, and I'm going to be out to see you in the next 2 weeks. Is that okay?
Yes, thank you.
Okay. And I'm going to have the phone number I'm going to have on there is going to be my cell phone number. So if you need anybody to call or have family call me directly, okay?
Okay. All right.
When did we set your other case, Mr. Price, to come back?
Your Honor, we had that, I think it's April 12th, I think.
Is that too far out for this one?
I don't believe so, Your Honor. If I got to get him this information and discuss a few things, he also has some co-defendants with all this, so I don't know if we want to set those dates the same.
Okay.
And just reading through this briefly, I think there's probably 3 or 4 people wrapped up in this.
Well, that wouldn't surprise me. Yeah, we just did Mr. Busey. He's one of them, but I don't remember when I've already forgotten.
And I think Mr. Depp might be involved with this, Your Honor, and
April 12th. Yeah. Yeah, we've already got at least one of the co-defendants on April 12th, so I'm just going to make an executive decision out of the judicial branch and put it on April 12th.
Not much I can argue with that, Your Honor.
All right. Thanks.
And did you hear that, Mr. Miller? We're going to come back in about 5 weeks, all right?
Yes.
Okay. And whenever we meet and whenever we go through discovery, we can file a motion to adjust your bond if at that time we think it's appropriate, all right?
Okay. All right.
All righty?
Yeah.
All right. Thank you.
Thank you.
Let's see. Yeah, go ahead.
I was just going to call a case, but you can go ahead and call whatever you want.
Well, I thought Mr. Price might just have one more case.
I got 2 more, Your Honor.
He does. He has.
I got Mr.
Shirley
Wilson and I got Miss Shirley.
All right. Miss Shirley.
And
who's the other case? All right.
And Your Honor, I don't want to jump anybody's place, but I was appointed to her case in this county. She has another county case that's just a pox charge. But really, we're waiting on 18 CR 192 out of Monroe County. That's going to be a trafficking charge. That was set to go to trial the first week of February. And I haven't seen any updates as to when that was reset because I know the Supreme Court shut down everything till April at least. And I don't want to speak for the prosecutor, but I think that's going to judge exactly where this case goes.
Yeah, that one's a lot further along. And I did know it was set for trial. And of course, we all knew when she picked up this case, it was pretty clear that that trial wasn't going to be able to, or that they weren't going to be able to have it. So Ms. Gardner, what are you thinking about getting another pretrial on this one?
I don't have an objection to that, Judge. She has a co-defendant, Jason Smith, who's also on today. I'm trying to join again by my computer instead of my phone so I can hear better. Sorry.
That's all right. Yeah, here you go.
Miss Shirley, I sent you discovery out to the detention facility. Have you received that?
Yes.
Okay, thank you.
That's fine.
Okay.
Ooh, Lord.
Oh my gosh. Okay, I'm so sorry about all that.
A lot of reverbs. No, that's all right.
Oh gosh.
Okay, so Mr. Spears, you're on here too. Do you have Mr. Smith?
Yes.
All right. While we're talking, they're co-defendants. So while we're talking about one, we might as well at least be talking to you about the other one. Do either of you have a problem if we put, do you know who's got her case? Greg, do you have her case in Monroe? Do you know who has it?
Your Honor, a former DPA attorney out of E-Town, Brad, has that. He moved up towards, I think he's in the Danville office now.
Oh, yeah. I remember that guy.
I'm sorry, Greg. I didn't mean to jump in on you.
I'm glad you said that because I didn't know that. But he's still in E-Town.
He could see the look on your face. That's why he jumped in. He could see you searching your memory bank for that. Well, I mean, what I'm thinking is that we might ought to go out to something along the lines of, towards the end of April or something, because I would say that when you get back into Monroe County in, 2 weeks for the pretrials over there, they'll be picking another court date or another trial date for her.
So at least, Your Honor, could I suggest coming back that first week in May? I know it's far out, but I'd much rather her not just keep bouncing around. At that point, we should have a definitive final pretrial and trial on that 192 case.
I can live with that. That's May 3rd.
I think that would be a lot more productive.
Mr. Spears, can you live with that in your case?
I can live with that. If something changes, I'll bring it to the attention of the court. But I think that'll work because I believe Mr. Smith is a state inmate currently, but I think he's got 2 months left to serve, so that should be about the time nearest serve out. So if something changes, I'll let the court know.
Yeah, I mean, if there's a reason that we need to get back in, I'm more than happy to do it sooner.
Okay.
You know,
and Your Honor, I would be discussing Ms. Shirley's bond, but I believe for Monroe County, the judge put it on at no bond. She's just been held at flat out no opportunity. So I think it's kind of moot at this point. If something changes, I'll definitely bring it to the court's attention.
Yeah, that's perfectly all right. And that was at least the fact, as far as I was aware of it the last time I checked, was that there was a no bond hold on that. All right, so May 3rd, 1 o'clock. Okay, thank you.
Thank you, Ms. Shirley. And Your Honor, I have one more case. It's Mr. Wilson. He's out, and I think it's a pretrial violation hearing.
All right. Do you have a last name on him?
Jeremiah Wilson, Your Honor. He's actually, he just logged on. He's on the side right there. I saw him.
Yeah, I see him right there. Yeah, sure. I see him.
Am I missing him on the docket? I don't see him.
Well, he's actually, his next pretrial is set for May. There was a pretrial problem where he didn't show up for 2 drug tests at the end of January, Your Honor. That was the first time I just jumped on this case. So I have that violation. We were set for that. But I can tell the Commonwealth and the court that whether or not he missed those 2 cases, he has a DOT physical that he has to pass in order to drive for Coca-Cola. He passed that test. He has passed drug tests from that exact same date. I would ask that if I can provide that to the Commonwealth, maybe we can clear up that issue of whether or not he was testing or not and just clarify what number he needs to be calling and who needs to be contacting who.
Yeah, I'll tell you what, let's do. If he's already got a pretrial date in May, let's leave that on. Let's let you get what you've got and show that to the Commonwealth and see if that, allows them to refrain from filing anything. I'm going to get a phone number from him. I'm going to give him the U-turn. The U-turn people are the ones that call for these tests. I'm going to give him a phone number and tell him, and Mr. Wilson, I guess I'm talking straight to you. So I'm giving you a phone number and then tell you to call them tomorrow by 9 a.m. Okay. And then they will give, they'll take some other numbers or whatever, and they'll work it out with you where they've got ways to get in touch with you. All right. Can you hear me?
Yeah, I can hear you.
All right. What's their number? Do y'all have it jotted down anywhere? See you. All right. Can you write this down?
Yeah.
All right. It is 270-629-2130. Can you see that?
If you can back it up a little bit, Your Honor. Much better.
Yeah, I can't see what. All right, you got it?
All right.
So you need to give those folks a call. They usually open between 7:30 and 8. So, I'm going to give you a little window there. Call them by 9, okay?
And Your Honor, there is another issue. And I'm sorry I didn't have something filed on this, and it might be something that would best be brought up in May, but he's charged with burglary. This is not a drug offense. I do not have his previous history pulled up, but I would have to question if he can come off of that requirement that he have drug and alcohol testing. One, it's an exorbitant amount to be paying in order to do those things. He has these DOT physicals that he has to pass, so he has to be tested. And if there's anything that comes up, all hell's going to break loose, to be completely honest. So if he's getting tested through work, can we use that instead of having to go through U-turn?
Well, I'm gonna be honest with you. Since we don't have him on the docket, so I don't have his file here, and the only way I know that he's even supposed to be going there is because you all are telling me that he is. So what I'm going to ask him to do is call Julie, and then I'll get his file and look at it, and we'll see what, because I don't know. Probably what happened was he probably got ordered to do that in district court. And so that I can leave people out on bond when they get indicted, I usually just say, you know, remain on the same bond. And that way I don't have to arrest you. And that's probably what I did in that case. So I just kind of adopted whatever the terms were. And I wouldn't have really made any sort of independent look at it, because I'm not sure that I've seen him since then, or at least nobody's asked that. So I'd be happy to look at it and see, you know, there isn't any reason to be getting tested twice by two different entities, I don't think.
Correct. And Your Honor, what I'll do is I'll get that information from Jeremiah. I'll scan that and get it over to the prosecutor, but I'll also file a motion just giving you notice that this is the information that I have. And if you'd like to take that pretrial requirement off, it would be nice.
Yeah, I'll tell you what, when you file that, if you want to just, if you don't care to email me a copy, because a lot of times when things get e-filed, I don't see them until the court date.
Could I get a good email for the court, please?
Yeah, it's John Alexander at kycourts.net.
And Judge, just for the record, this is my case, and you know, I don't want someone to be tested twice, but I don't know about these DOT physicals if he's given advanced warning of when he's supposed to report. That's the whole purpose of that bond condition. But I'll take a look at what Mr. Price has and what these tests show.
Yeah, and I will as well. I mean, you know, I agree with you that I don't want to just assume anything, but I also don't necessarily want to make a guy just keep getting tested superfluously. So we'll figure it out.
I understand that.
Mr. Wilson, do you have any questions about what's expected of you right now?
Yeah, I mean, like I have no criminal record with, you know, a couple of misdemeanors.
Well, as of right now, you just need to check in with U-Turn tomorrow, get me that paperwork, and we're going to start working on it, all right?
All right.
You still have to follow these expectations till the judge tells you you do not, correct?
Right.
Okay.
All right. Thank you all.
Thank you, Your Honor. I think that has everything on my docket, Your Honor. Can I be excused?
Okay. Yes, sir. Thanks.
Thank you, Your Honor. Y'all take care.
See you, Greg.
Okay. We can ask her. I mean, you know, she may be able to test, be satisfied. I don't know. Vicki Wilburn.
That's my case, Judge. There should be an agreement in the file.
Oh, yes, sir. Miss Wilburn, how are you today?
I'm good. How are you?
I'm all right. Can you raise your right hand for me? Do you swear or affirm that you'll tell me the truth, so help you God?
I do.
All right. Okay. I had to stand up. I've been sitting too long. I'm going to show you your motion to enter a guilty plea. All right. It's right here. Can you see that?
Yes.
Does that look familiar to you?
Yes.
That's the signature page. Is that your signature?
Yes.
All right. This is your offer page.
Yes.
And that is the signature page for that document.
Yes.
Okay. Last but not least, there's a pretrial diversion order. It's right here.
Yes.
And if I fast forward ahead to the signature page, your signature is on that, right?
Yes.
Did you go through and read all these documents before you signed them?
Yes.
If you needed to ask your attorney any questions, did you get that opportunity?
I did.
Did they, in fact, did Mr. Berry, in fact, discuss these things with you to your satisfaction, you know, to the point that you feel like you're pretty sure you understand what's happening?
Yes.
All right. Did you make sure that you understood what everything meant before you signed it?
Yes.
Do you feel like you're under the influence of anything today?
No.
You feel like your judgment is impaired for any reason today?
No.
All right. Do you understand that you have a right not to incriminate yourself and you waive that if you plead guilty?
Yes.
Do you understand that you have the right to a trial by jury where the Commonwealth has to prove guilt beyond a reasonable doubt? You can confront and cross-examine the people that give evidence against you. You can put evidence on in your own defense, and you can file an appeal with a higher court. And you waive each of those rights if you plead guilty.
Yes.
All right, Ms. Wilburn, the Commonwealth has made the following recommendations here. Number one, count one, possession of a controlled substance, first degree, first offense. That is a Class D felony. On a plea of guilty, the Commonwealth would recommend a sentence of 2 years. Count two, drug paraphernalia. On a plea of guilty, the Commonwealth would recommend a sentence of 12 months. The 12 months and the 2 years would run concurrently with one another for a total recommended sentence of 2 years. The Commonwealth would agree to pretrial diversion of your 2-year sentence on the condition that you are supervised, that you follow the rules of pretrial diversion, which would include no new arrests or violations of the law, illegal drugs, reporting, you know, there'll be reporting requirements, et cetera, and that you enter and complete a long-term substance abuse program, including any aftercare. You understand all that?
I do.
Are we talking about this being supervised by probation and parole? Is that what we're talking about?
It would be, Judge.
Yes, Judge.
Okay. Well, I didn't know. I knew that she was on, you know, I knew that at one time Miss Atkins was trying to help her get into a treatment facility, and I didn't know if that had been done, if we had a bed day. You know, I was just trying to explore what's
Judge,
going on.
what Bethany has been working on it, and she's getting her into an RKC facility.
Okay.
And she just asked that as part of your order in this, it should be ordered to go to RKC.
Okay. Yeah.
And she can, I talked with her, I believe last week or the week before, about how long it's taking to get somebody in RKC now. She felt like it was pretty safe to say just very quick, a day or two.
All right. Just so Ms. Wilburn and I both know what she's agreeing to, is the Commonwealth's position that she'll remain in, or I guess was that talked about by everybody, whether she would remain in custody till I get her bed date?
I don't believe that was taught. I don't believe that was part of the agreement, Judge.
Okay.
I mean, I think our standard position is that they do until, you know, they have the bed date and let them out to prepare a little bit. But this is John's case, so I'm speaking for him. But.
Yeah. Well, you know, there is nothing in the file. I mean, in the plea offer, and I agree that is kind of traditionally what we do, but I don't want, you know, to kind of, I've used the term bait and switch. I don't think that that's what anybody intended, but I don't want her to think, I don't want to be changing the agreement on Miss Wilburn if she entered an agreement and she didn't think that was part of it, because that is not written in it, that, you know, that would be her deal. What I'm concerned
but
about,
it's also not written in that she would get out too. Correct. I mean,
well,
I don't have that.
But it's pretrial diversion. So, I mean, you know, you don't normally put people
I understand that.
in pretrial diversion.
I think I just what I said, I think that's how I guess we'll start putting it in, but I would say that he was wanting her to stay in until residential treatment was part of the offer, and that's what they had talked about. Then yes, I think that.
Oh, I think that it is certainly if I was looking at one of these, I would assume that, but I mean, she had never done one of these before. So I don't expect that she assumed it. That's why I'm trying to talk about it.
Okay.
If Greg thinks that she's going to get in, here's where I'm going with that. The last time I talked to her and let her out of jail and told her to report to U-Turn on the same day, she didn't report. And then when she got down there, she had been, you know, her problem was bad enough that she had used methamphetamine, possibly, if my memory serves, but I can't remember, maybe even intravenously, but between when I let her out of jail and when she got to so I mean, there's a problem that I'm not sure she has a real good grasp on. And what I don't want to do is sabotage the whole thing by letting her out of jail and she's out 4 or 5 days. And, you know, I'm trying to worry about her rights and so forth. But in the meantime, she's out here, you know, ODing or using intravenous drugs. And then she tests positive when she goes to the facility and they kick her out. You know, I mean, I'm trying to do what's best for her. I don't want to keep her in jail because I'm a pain in the butt. I want to keep her in jail until she can get a bed date because she's candidly asked for help and I don't want to sabotage her.
Can I say something, Judge?
Yes, you may.
If you do keep me, is it possible that I could have like a 2 or 3 day furlough? My grandmother is on her deathbed. She's really sick.
Yeah. Yeah. Well, I think Mr. Berry is indicating that if we do this today, you might have a bed date within just a couple of days. Is that what you think, Greg?
That was the feeling or the conversation I had with Bethany.
All right.
My experience with these rehabs is they're up 1 week and down the next. You don't know for sure when they're going to have something available, but since RKC has numerous facilities, it's generally easier now to get somebody in one of them. It's a quicker process than it used to be. We used to wait sometimes 2 or 3 months to get somebody in.
All right. So I'm gonna let me finish this and then I'm gonna tell you what we're gonna do. All right, Miss Wilburn, the 2-year recommendation from the Commonwealth and the pretrial diversion and the entering complete rehab and all that's what you understood, right?
Yes.
All right. We need to specify which I wrote it on that, but I'm going to write it on the Bethany wants us to specify that she's going to do it in our cases in the paperwork. Okay. All right. Ms. Wilburn, are you admitting to me that on February 14th, 2020 in Barron County, you knowingly and unlawfully possessed methamphetamine and drug paraphernalia?
Yes.
All right. Then I'm going to accept your plea of guilty and I'm going to start looking at this pretrial diversion here. Order.
And also, Judge, to let you know, I do have a place to stay with my mother. My mother hasn't spoken to me in a year because of the drug issue, and she's finally allowing me to be back in her life.
Okay. All right. So this is what we'll do because and I don't think that I don't mean I'm trusting Mr. Berry like he would be lying to me, but I'm trusting that Bethany gave him as best of information as she could, and that, you know, hopefully maybe within 72 hours we'll have you a place. And if that's the case, there wouldn't be really an opportunity for me to let you out early to go anywhere, because if I find out that quick, you know, so this is what I'm going to do. I'm going to go ahead and accept your agreement and grant your pretrial diversion request and allow you to be released from custody on the following conditions. Number one, you're going to report to probation and parole tomorrow.
Yes,
all right.
sir.
And Officer Bragg is going to tell you in just a minute when that's going to be. But I'm assuming he's going to tell you to report in person. That's what I hope he tells you, because you're also going to get drug tested.
That's absolutely fine.
All right. And I'm not saying that because I don't trust you. I'm saying it because I want you to know it. And maybe if you just need a little tiny push to keep you from doing something, that'll be enough.
That is enough.
All right. I'm also going to ask him, and I don't know that this is possible, but I'm going to ask him to at least keep keep in mind, whoever catches your case down there, that from now to when you go into treatment, they may call you at any time and take another drug test. I mean, even if it's 2 in the next 2 days, or 3 in the next 3 days, or 2 in the next 3 days, or whatever.
I'm okay with that.
I want you to realize that you can get a test at least daily.
And I was going to actually suggest that I could report daily if need to.
Yeah. Well, I'm going to leave that up to them after they talk to you, but that's what I hope they can do. I don't want to boss them around. You know, they're doing the best they can at the probation office too, but I want them to see you as frequently as they can see you till we get you in that bed.
Understand.
And
all right.
Judge, I would just say from the Commonwealth's perspective, and I am speaking for John, but I feel like he would say the same thing, that if Ms. Wilburn does mess up, she tests positive prior to entering treatment, that we would file a motion to avoid diversion. And I don't know that treatment would be part of anything that we offered as a potential resolution in that revocation hearing.
Oh yeah. I mean, we got to get on top of this, Ms. Wilburn. And, you know, I don't want to be unfair to you, but I'm a little worried that letting you out of jail right now is actually being unfair to you. So I also don't want you to go off to treatment and not get the chance to see your grandmama or anything like that, because I'm not sure that would be fair either. So I'm just trying to do the best I can, but you've got to hold up your end.
I will.
Okay.
Thank you.
All right. So Officer Bragg, tell her what she needs to know, please, sir.
Can I have, what's your address going to be while you're out?
It's 2638 Sulphur Well Knob Lick Road, Center, Kentucky, 42214.
And do you have a phone number?
My mom's phone number, it's 270-590-9806.
Okay. And so you need to report to the office tomorrow at 9:30.
Okay, I can do that. My mom will bring me. Do I need to see you?
Your office, since you live in Metcalfe County, your officer is going to be Officer Ford, and she's going to be there tomorrow as well. So you'll see one of us.
Okay. Thank you.
Mm-hmm.
You'll get drug tested. All right.
That's fine.
All right.
I'll be clean. You won't have any more issues with me.
Oh, listen, I promise you, I know that that's what you intend and that's what I hope, but I just, you just need to know that. Okay.
Thank you.
All right. Good luck, ma'am.
Thank you.
Got Mr. McCandless. Is he there?
Yes, Judge. Yes, Your Honor.
Judge, I think on Mr. McCandless's case, Josh and I need to discuss some things. How long do you think you need, Josh?
If we could go out 2 weeks, I think that would be good. And if we and Judge, I'll go ahead and I was going to ask you as well to take his bond under advisement too, but since we're only going to go out 2 weeks, I'll just hold off on that motion until see if we can get something resolved. If not, I will go forward with that bond motion. But talking to Mr. McCandless today, I took his case over from Tyler. I feel like we have a possibility of possibly getting this resolved without going to trial.
Okay, well, I just point out we do have this set for trial in July. So we've already taken care of that part at least. And other than that, I'll see you in, what'd you say, 2 weeks?
Yeah, March 15th.
All right, March 15th. Thank you.
Thank you.
Bonnie, you got anybody else down there?
No, Judge, that's all I've got.
All right, thank you.
Thanks, Judge.
What about Colton Keller, Judge?
Yeah.
I thought he was on for today.
He got transferred to Montgomery County, Josh.
Oh, okay. Hey, Bonnie, when did you get transferred? This weekend?
Saturday, yes.
Saturday. All right, thanks. Okay. I'll make a note of that.